Today's lecture will focus on Chapter 25, Employment Laws. Let's look at a brief historical background of employment laws. Before the 20th century, early employment laws in the United States controlled and restricted workers. Now, we'll talk about minimum wage laws here a little bit, but can you believe that there used to be a wage maximum law, which means no matter how much you work, you could only make a maximum wage? So it wasn't until the 20th century or the 1900s that brought socio and political movements that allowed for more worker protections, which we'll talk about here on the remaining slides today. First type of laws I want to look at are what's called health and safety laws. Let's start with workers' compensation laws. So most states enacted these types of laws around the early 1900s, 1917 to 1925. These laws were designed to compensate employees for workplace injuries. Thus, liability was imposed on the employers for injuries to their employees occurring during what's called the scope of employment, without regard to fault. In essence, this was a compromise between what the employee wanted and what the employer wanted. The employee, he or she gave up the right to sue his or her employer in exchange for the high probability of recovering without costs, such as a lawsuit. The employer gives up the right to use negligence defenses in a lawsuit in exchange for limited payments to the employee. Thus, there's no punitive damages. Employers must provide disability income, other things such as medical treatments, and schedules amount for specific injuries or death. The injuries have to be work-related. So they must, one, arise out of the employment. So for example, a husband who goes to his wife's office and shoots her, she can't recover under workers' compensation because the injury was not related to her work. Second, the injury must be in the course of employment. Thus, injuries occurring on the way to or from work are not within the scope of employment. Thus, you can't recover for workers' compensation. It seems ironic that we have workers' compensation laws in the early 1900s, but it wasn't until 1970 that Congress said, maybe we should look at these employers who are providing unsafe work environments. And thus, 1970, the Occupational Safety and Health Act was passed, otherwise known as OSHA. Okay, so it applies to all types of business that affect interstate commerce, and we know that interstate commerce is broad, so even if you have one employee. So generally it imposes a duty on employers to prevent workplace hazards that may cause death and or serious physical harm. Employers must keep a record of fatalities and injuries that require hospitalization. And really what the main thing is that the OSHA inspectors may inspect any workplace at any time for any reasonable time without notice. Other things dealing with health and safety, let's look at more recent legislation, FMLA, otherwise known as the Family and Medical Leave Act. This was passed under President Clinton in 1993. So it provides job security to employees that have serious health conditions. The main goals of FEMA were to provide job security for employees with serious health conditions. That's one. Two, provide reasonable leave periods for family-related health issues. And three, to make workforce more accommodating to both women and families. This applies to employers with 50 or more employees. And what happens is if you qualify for FMLA leave, the employer must provide up to 12 weeks of unpaid leave per year. and it could be for such things as the things listed on this slide, such as a serious illness, the birth of a child, or adoption of a child. In 2008, it allowed for extension for military family members. Thus, the employee's job is protected during this unpaid leave. In order to be eligible, the employee must have worked at least 1,250 hours during the previous 12 months. Healthcare is of premium importance to most everyone, especially given, the pandemic that we're under right now. In 1985, COBRA was enacted, and this allows for the continued availability of health insurance at employer group rates to certain terminated employees for up to 3 years. So what that means is if you've been fired or if you've been let go, you can still get your health insurance at the lower employer rate. However, if you're unemployed, it's still rather expensive to purchase healthcare insurance. In 2010, under President Obama, the Affordable Care Act was passed. Oftentimes in the media, it's been referred to as Obamacare. What this allows is for adults up to 26 may stay on their parents' health care plan, and probably most importantly, people cannot be denied coverage for what's known as quote-unquote pre-existing conditions. The intent was to provide health insurance to almost all Americans, but there are almost just as many Americans who still don't have health care under Obamacare than when before the Affordable Care Act was passed. Let's move over to legislation that deals with wages and pensions. Under the Fair Labor Standards Act in 1938, the federal government finally established a minimum wage and overtime requirements. The original minimum wage, by the way, in 1938 was 25 cents. And although that sounds low, if you take into account inflation, the minimum wage of 25 cents back in 1938 was worth more than today's minimum wage, federal minimum wage of $7.25 per hour. By the way, states have higher minimum wages. So for instance, in California, as of 2020, the minimum wage is $13 for employers with 26 or more employees and $12 for employers with 25 or less employees. So not only is there a minimum wage, it does allow for overtime provisions such as time and a half for if you exceed 40 hours per week. Now these are all for hourly employees. It does not include salaried employees. Okay, the time worked in that 40 hours per week includes time the employee is quote-unquote suffered or permitted to work. So you get paid if you're voluntarily working to increase your knowledge or on call or for short rest periods. Finally, oppressive child labor is prohibited. That means no child under 14 can work, and if you're an older child than 14, you can't work in hazardous jobs. Now, many people think ERISA, the Employee Retirement Security Act that was passed in 1974, guarantees a pension to all employees. That is not the case. However, what ERISA does regulate is both the management and vesting of established retirement plans. Vesting is the employer's legal right to a pension, cannot be taken away once vested. Let's quickly talk about collective bargaining and union activities. Now, you see 4 different acts on this slide. I want you to look at the first 2 acts as being pro-union, and then the final 2 acts on this slide to be anti-union. So draw a line in the sand. The Norris-LaGuardia Act prohibited what was known as yellow dog contracts. And those were contracts where an employee promises not to join a union as a condition of employment. The Wagner Act, passed 3 years later, finally gave the rights of workers to organize and collectively bargain. bargain union is usually a union certified as the exclusive representative after winning a majority vote that can bargain on such things as wages and working conditions. Now let's draw a line in the sand and notice that after World War II, big money got involved or big business got involved and passed legislation that was more anti-union. Under Taft-Hartley Act, it was a law that more equalized the excessive powers of unions and prohibited such things as hot cargo contracts, and those were an agreement between an employer and a union whereby the employer would refrain from dealing with products of another company that's unfair to the union. Finally, several years later, the Landgraf-Griffin Act had further checks on unions, and the idea was to promote honesty and democracy in running the union's internal affairs. And these two laws and subsequent legislation has had a stifling effect on unions in the private workforce, not public, but private workforce. In 1955, almost 40% of employees in the private workforce belonged to a union. That number is down to 10% or less today. The next few slides we're going to talk about employment discrimination. Now, I want to quickly talk about the Equal Pay Act of 1963. It prohibits gender discrimination in pay, and while that's nice, there are exceptions. Different pay rates are allowed for such things as seniority or merit, or if the work is a piecework or incentive pay, so you get paid more for what you produce. Now, even though we have this act, I would still argue that women, by and large, are paid a lower amount than men today. I want to spend a lot of time on Title VII of the 1964 Civil Rights Act that was modified in 1972 and 1991. In fact, this is the basis of your second essay question on your final exam. So Title VII of the Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, religion, sex, or national origin for hiring, firing, promoting, or fixing rates of pay. Gender was added later in 1972. Even this applies, by the way, to 15 or more employees. And again, age was added later in 1972. Even though the term discrimination was never defined in the 1964 Act, it talked about two different types of discrimination. One, intentional discrimination, and two, discriminatory impact. Under intentional discrimination would be such things as refusing to adhere to the Act, e.g. not hiring people who are, let's say, Asians or African Americans. Discriminatory impact is a neutral rule that has discriminatory impact. So for instance, you say you can't hire at least someone who's 5'7" or 140 pounds. It tends to eliminate women and minorities. In addition to discrimination in hiring, it looks at other aspects. One aspect in particular is sexual harassment. Title VII talks about two types of sexual harassment. One, a quid pro quo, and two, a sexually hostile environment. Under a quid pro quo, that's where you get job benefits in exchange for a sexual act. Second, under a sexually hostile environment is not instituting or enforcing a sexual harassment policy. Title VII also deals with affirmative action, and affirmative actions are plans to increase the proportion of either women or minorities in the employer's workforce or higher level positions within the workforce. In order to be effective, an affirmative action plan must be temporary, which means until the goal is reached, and then you stop it. Number two, it must not unduly restrict job opportunities for those not included in the plan. And finally, third, It must not involve the hiring or promotion of unqualified workers. Finally, the modification in 1991 of the Civil Rights Act allowed for plaintiffs now can sue for what's known as punitive damages, which means to punish and deter. Before, you could only sue for compensatory damages. Now you can sue for punitive damages. One final thing of note, there is one type of discrimination that's allowed under the Civil Rights Act. So any sort of discrimination based on religion, sex, or national origin may be allowed for what's called a BFOQ, which is a bona fide occupational qualification. So for instance, a Catholic church wants to hire a Catholic priest to conduct Mass as opposed to someone who practices a different religion. Or a locker room attendant in a men's bathroom must be limited to males. So sometimes there are exceptions for bona fide occupational qualifications. Please make sure you look at this in the textbook, as this will be a major part of your final exam. Other things dealing with employment discrimination, let's talk about age. So employers with 20 or more employees cannot discriminate on the basis of age, and age is considered workers over 40. There are BFOQs exemptions in place. So for instance, if you're hiring a young actor, a teenager, you don't have to hire someone who's over 40. The Americans with Disabilities Act, which was passed originally in 1990 and amended in 2008, provides coverage against discrimination on the basis of a physical or mental disability. And what it does is protects qualified individuals. And when you hire someone here, you must provide what's known as quote-unquote reasonable accommodations that do not provide an undue hardship to the employer. Finally, the Genetic Information Non-Discrimination Act was recently passed, which prohibits the collection of genetic information by employers from their employees and their applicants. Other issues with hiring and firing is that employers usually use what's known as employment at will, which means employers can fire most employees for any reason or for no reason. That's the general rule. There are exceptions, however, to the employment at will doctrine. The first is public policy. So, for instance, if you fire someone for exercising a statutorily recognized right, duty, or privilege, that would be an exception for, so usually someone for filing a improper workers' comp claim. In addition, there are protections for whistleblowing, and that's reporting employer wrongdoings to appropriate agencies and personnel. The second exception is for an implied contract. That could be found in such things as personnel manuals, handbooks, or during the job interview. Express terms of a contract would be the terms of such things as a collective bargaining agreement. Finally, the third exception is the implied covenant of both good faith and fair dealing. So those are terminations based on such things that have nothing to do with job performance or an ulterior motive. Some courts will recognize this, other courts will not. Finally, let's talk a little bit about the right of privacy for employees. Employees do have certain rights to privacy. Under the Employee Polygraph Protection Act, it prohibits private employers, not public employers, but private employers from using lie detector tests outside of specific investigations. In addition, use of tests involving public employees and applicants are protected by the Fourth Amendment. But really, the bottom line is that private employees have limited protections under the Fourth Amendment because, as you know, there are first 10 amendments protect against state or government intrusion. So really what you need to know is, in this day and age, you have a very limited right to privacy as an employee from your employer. This concludes our lecture on Chapter 25, Employment Laws.